particularly pleased to offer welcome remarks this year as we convene our annual Meet with the Court Symposium. Among the topics to be discussed today is due process in the industrial relations context and indeed in the wider context.
These two conventions here sets out some specific case where disciplinary measures must not be applied. So the first one is the abolition of forced labor convention number 105, which is one of the 8 fundamental conventions of the ILO. And this convention says that the forced labor must not be used as a means of labor discipline, which means, for the purpose of our meeting today, that discipline measure must not go as far as forced labor.
After a fair and proper investigation, ascertain who is the culprit, because that will certainly obtain under our law of unfair dismissal, that you can't point to an individual and punish them for having done what you allege they have done without a proper investigation being carried out. And that will entail you giving them notice of the charge, setting a date for the hearing that is convenient to all parties, permitting a friend to represent them. Some people bring lawyers, to which the employer objects. That the charge is laid, the employee is given a chance to face his or her accusers and to cross-examine them, and ultimately that the decision is made by the employer that that person was indeed or is reasonably suspected of having committed the offense.
With the concept of due process that you've listed as the components, one of the points to be considered is a reasonable decision. In some instances, the employer has complied with the due process, but by all intents and purposes, the reasonable decision should be to allow the worker to return to work, but the new terminology utilized by employers are, on a balance of probabilities, the worker was terminated. Is this decision of the employer a reasonable one?
In my view, and in looking at the cases, what the industrial court will then look at, if all the processes have been adhered to, the industrial court will still look at whether the dismissal in the circumstances was harsh and oppressive, meaning that it was just unreasonable. Even if we accept everything that the employer alleges. For example, in the Barclays Bank case, where the employee sent this rude and abusive letter to his manager, which the court found was really very bad. Yet the court thought that to dismiss him was harsh and oppressive, because you have to take into consideration that he has been employed with you for 12 years, and this is the first time he has any misconduct has been alleged. And thus, even though you may have crossed the barrier of good industrial relations practice, meaning due process, yet you have the harsh and oppressive, which speaks to the reasonableness or the unfairness of the decision.